Thanks for joining us today as we go through the power and control wheel spoke by spoke. This is part of our intimate partner violence prosecution series, and I'm really happy today to be here with my colleague, John Wilkinson.
Hey, Jane.
Hi, John. John and I are both attorney advisors with AEquitas. We are a mostly federally funded, some private funding as well, nonprofit organization. And we are really pleased to have the opportunity to provide innovative, informed, and hopefully really practical resources and strategies for you, prosecutors, allied professional, anyone that's doing this work involving intimate partner violence crimes, stalking, sexual assault, and human trafficking. And we do that in a lot of ways, including our website, which has a lot of public-facing resources in the form of webinars and written publications. We also hold and host training events, anything from small one-office events to really large-scale national events. And of course, these days, a lot of Zoom events. And I think, John, you'll probably agree with me that probably one of the favorite things that we do as attorney advisors with AEquitas is provide one-on-one consultations. That means you can call us, email us, if you have a case-specific question or even a question about office policies, if you need case-specific research, maybe just even a sounding board to talk through voir dire strategies. We're here for you. We're also very proud to be involved in several national partnerships and initiatives, including the Sexual Assault Kit Initiative, the Enhanced Collaborative Model Human Trafficking Task Forces, and a really wide and diverse number of innovative prosecution solution grants. You can follow us online, check out our website. We're always pushing out new trainings, new resources, research, and opportunities for you. So however you're comfortable, follow us to one of these social media platforms as well. As I mentioned, we're supported in this particular project by the Office of Violence Against Women, part of the U.S. Department of Justice. We're so thankful for their support, but do want to give the caveat that not everything John and I say today is necessarily going to reflect the views of the Department of Justice. All of our work, like I said, we strive to be very informed and innovative. So our work is informed by the work of others. And we will share that with you using proper citations and acknowledgements. And we do this under the fair use claim. So let's get started, John. I think today, as we set the sort of stage for the rest of this series, I'd really love to talk about the power and control wheel as a tool for prosecutors to help us sort of gather and identify intimate partner violence. Through that, we can enhance victim safety and maybe look towards litigating the admissibility of other bad act evidence. But we need to first identify it and find it. And so this tool, I think, is a great way for us to start. So are you familiar with this, John?
Yes, I am. And I agree with you 100%. I think it's something that prosecutors don't necessarily think applies to them. It's kind of an advocacy tool, but they couldn't be more wrong. It is really important for us to understand what's going on in these relationships and what these victims are being subjected to figure out how we're going to move these cases forward in the most impactful and powerful way possible. They're difficult cases to try, and this is a very helpful tool to help us figure out how to get to guilty.
So we're going to go through literally spoke by spoke, but I wanted to start off by asking you maybe a little bit more, like, how is this something that prosecutors can use? Why should we be familiar with it beyond just sort of maybe understanding basic dynamics?
Yeah, well, I mean, it is important to understand the basic dynamics because we have to educate the fact finder, whether it's a judge or jury, about what's going on in these cases, in these domestic violence cases. And the power and control wheel is what's really going on there. That's what sets these cases apart from just a fight that went bad, an argument that escalated beyond what we'd normally expect, or, oh, it was just a fight that got a little out of hand. It's power and control that's going on. And when a prosecutor understands that it's power and control and what power and control is, I think then you're able to use that information and identify it in your individual cases and explain it to the judge and jury. A classic theme in your domestic violence case is, this is not a case about a fight that went bad. This is about power and control. And that is what almost all of these domestic violence cases are about.
Yeah, and I actually loved having this wheel like at my desk because it helped guide when I met with victims or when I was putting together my direct examination. I almost sort of used it, I hate to say checklist, but I almost wanted to make sure, have I looked at this tactic? Have I made sure I've asked those questions? How can I bring out that evidence?
Yeah, I think that's a great strategy. And, if we don't ask about those things, it's not going to fall in our lap. Victims don't know that that's important, that the offender does something to isolate them, or that the offender uses economics to control them. They don't know that that's important to share, but it is important for us to understand that if I don't know it, I can't get it in. If I do know about it, I might not get it in, but I might be able to figure out a way to convince the judge, hey, this is important evidence. It explains what's going on. It explains motive. It explains intent. It explains to the jury what's really going on here. Because when the jury hears or the judge hears about these power and control tactics, those are things that light bulbs go off. That's not a typical relationship. There's something else going on there, and that is concerning.
Mm-hmm. And I think you already sort of mentioned at the heart of this, and literally at the center of the wheel, is this idea of power and control.
Yeah, and that's what's driving the abuser, right? It's about exercising power and control over their significant other, whatever the relationship is, and that's what sets it apart. That's what makes these cases dangerous, because it's not an equal relationship. It is not people trying to struggle through. Everybody has struggles in relationships. This is something else that's going on, a dynamic that leads to violence, that leads to other types of abuse. I mean, I think we really focus on the violence part, which is important. And of course, we want to stop that violence. But there's all sorts of types of abuse going on that are important, and that if we can bring them forward and shine a light on it, then maybe we can hold that offender accountable for all the things that they're doing, not just the one or two acts of physical violence.
I also heard someone talk about this, and it was really impactful to me, that it helps explain escalation, because an offender is only going to use maybe the amount of power and control they need to. They're only going to use the tactics they need to maintain power and control. And so early on in a relationship, they don't need to necessarily use the physical violence, because they can use some more subtle tactics. But then if that's no longer working, then there's this escalation, and that kind of continues. And I felt that was an interesting way to think about the power and control as well.
Yeah, I think that's really a great spot of an issue that goes on in these cases, and that escalation we see so often. So, when you get a case in court and you look at the defendant's record, and it's like, oh, they'd have no prior record. We know in these cases that doesn't mean things haven't happened before, and almost certainly there has been a lot going on. So it's important to recognize that these cases escalate, and by the time the criminal justice system gets involved, there's probably a lot to look at that has happened before this incident. And just what you were saying reminds me of an argument I used to make in domestic violence cases, particularly strangulation cases. And it would just be like, look, he used to be able to control her. Of course, you have to have the evidence to be able to make this argument. So if we don't find it, you're not going to be able to do it. But he used to be able to control her by just demeaning her and berating her. And then when that didn't work, he had to sort of grab her and shake her. And then when that didn't work, he'd have to slap her. And then when that didn't work, he'd have to punch her and kick her. And when that didn't work, he'd have to strangle her. And we know what's coming next, right? It's escalating, and it's going to get worse and worse, and it's going to lead to a fatal event if we don't interrupt it somehow.
I like that. I'm going to steal that from you, John.
So this is the thing with stalking too. Like, those are the most recalcitrant domestic offenders. It's not always, but it's usually a domestic relationship of some sort. And those guys don't stop. And we got to really make sure that the judge or jury understands that.
So when I was looking at this power and control and doing a little bit of a deeper dive into how it was developed, and hopefully we can share the link with the audience. The one of the women that helped develop it, Ellen Pence, she talked about how she interviewed all of the survivors of domestic violence who shared their experiences. And one of the things that came out and why the shape is the wheel is that it's sort of this idea of the violence kind of keeping all of this together. And another thing that came out was that some of the survivors would say, I don't really, I don't know, it doesn't feel right to me, this idea of this honeymoon phase that we sometimes see, because the honeymoon phase was just another tactic to keep power and control over me. And so this idea that there was sort of this wonderful honeymoon time of our relationship was really not how I viewed it. I viewed it as just one more tactic as part of the power and control. And I know, this is a good time to have a caveat, like this doesn't look the same for everyone.
Yeah, no, I think everything you said is like dead on. So how they develop the wheel is kind of amazing, right? Just to be able to gather that information and then to put it in this visual format that just makes it very easy to understand and to use. And so the physical and sexual violence that's sort of ongoing, as you said, that sort of holds it all together, or how Ellen Pence would describe it, is important. Particularly that sexual violence part, because we miss that a lot in these domestic violence cases. I think there's a lot more overlap between domestic and sexual violence than we identify. Because we don't proactively ask about that. It's another spot where victims may not be comfortable sharing that, or don't know it's important to share, or it takes time for them to get to a point where they're able to share that. So, but we need to be thinking about it all the time. And as you talked about the honeymoon phase, which is part of that cycle of violence. So there might be like a build up to an incident, and then there's an incident, and then there's a honeymoon phase where I agree with you. I think it is just another tactic. I'm going to apologize, or I'm going to do things to make things sort of normal, but are they ever really normal? And is this just another tactic? And is an apology an apology, or is it more, if you just didn't do whatever you would do, I wouldn't have to do I'm so sorry that we ended up that way, or, whatever they say or they did.
Yep. So now we're going to go through it. So the first one is this use of intimidation, maybe one of the ones that is more readily recognizable to folks when it comes to actual like threats and intimidation. But there's a couple of other things on this wheel I wanted to mention in the context of like, how are we going to find evidence of this? And could we find additional charges?
Yeah, so these are great questions, and intimidation is an important one. It's kind of the bread and butter of the domestic abuser, right? This is what they're going to use regularly, making the victim afraid just by a look, just by a gesture, things like that. Asking about that proactively is important. If we know, as they developed the wheel by talking to hundreds of abuse victims, if we know these things are regularly employed, why are we not asking regularly about them, just to identify that it's going on, and then I can use it in my case? But those looks, the gestures, the things that victims know when an abuser does something, I better stop, or I better change, or I better do something, or I better get out of there, are things that we should be asking about proactively. And, you're probably not going to just say to a victim, does he or she do anything to intimidate you? Because that's maybe not going to elicit the best information. I kind of want to know what is going on in the relationship, and ask about these things. Does he say anything to you that makes you feel like you shouldn't talk to the police, or don't want to cooperate with the prosecution? Has he asked you not to come to court, or has he said or done anything since this incident that makes you uncomfortable? And just try and get at what's going on in the relationship. You may not get everything, but let's give them, our victims, an opportunity to share what is going on, and what is important to them should be what is important to us. sometimes a victim might share a detail with me and it doesn't quite fit in my theory of the case or what I'm thinking of is important in the case, but it could be very important. Either a safety concern, or it could be something about the case that I'm missing. And so we do need to make sure they have an opportunity to share that information with us in their own way, and then act on that information or follow up and figure out why is that important to you.
Hmm. I love how, that idea of, not asking the obvious question, maybe asking something of like, you know, uh, when do you know things are going to get bad? Well, I know it's like this time of the month, or I know it's if he brings up my one colleague that I know he has a problem with, that I know we're about to go. So those are kind of cool things. I also, the more and more I started doing these cases, and the law enforcement I was working with and collaborating with got better and better at taking crime scene photos. Then I would be able to look around and nobody's mentioning it, but there's a broken lamp, there's turned over furniture. And if there's a shared home, that might not maybe list additional charges, but that property damage can be key, setting the stage, like, okay, this is what this looked like. And of course, we know a little bit about the abuse of pets as being a danger indicator, and there could be additional charges there as well, right?
Oh yeah. So I think all those things you're talking about are super important. Destroying that property is sending a message, right? It's not just I lost my temper. I mean, they're sending deliberate messages. And then the defense is, of course, well, you can't charge me with that because that's my property and I can destroy my property if I want, even if it's owned jointly. But sometimes it's something that's meaningful or important to the victim and they're destroying it that way. The pets one is a super important one too, that I don't think we proactively ask about all the time, although I do think people get better and better at it. As you said, investigators, just the more they do these cases, the more they improve on the quality of the information that we're gathering. But pets is a really important one because I think of it as, this isolation is another tool that they use, right? They're going to keep you away from your family, keep you away from friends, any support network you have. And a pet might be that last support network you have, that sort of comfort thing that everybody loves their pets and their pets love them. And so to remove that last element of support or to threaten a pet as a control tactic is something that they'll do. And there's statistics, and I forget what it is, but maybe like something like 2/3 of victims of abuse will go back to a relationship because of a pet, to get a pet, or go back to the home to rescue the pet and put themselves in harm's way. So that is another one we should pay attention to, not just because judges and juries really will punish people who harm pets. For some reason, they don't see it as the same as when two individuals are going at it, but because it is a way that these guys will get at their victims.
Yeah, and I think it's been shown to be like a red flag as well as for like high lethality. Is that right?
Yeah, and you had the other one on there about displaying weapons. I mean, it's in the power and control wheel, which is another high lethality risk indicator. So we do have to pay attention anytime there's a weapon. Usually officers do a very good job at the scene just to make sure it's safe. Domestic violence scenes are one of the most dangerous calls that an officer can respond to. Anything can happen, and you see these guys connected to other mass tragedy events or connected to the killing of police officers. So anytime there's a firearm, everybody needs to pay closer attention because even if it's not like the victim was shot or the victim was hit with the firearm, just the presence of the firearm, displaying the firearm is a huge red flag and a huge threat.
Mm-hmm. And so we're moving along the wheel. The next one is using emotional abuse. And we can see this is putting someone down, making them feel bad about themselves, name calling, also like gaslighting and playing mind games, making the victim feel like they're going crazy or they're imagining things. So knowing that that's the tactic, how does this affect a victim's ability to sort of then, think about leaving or think about like, what else could I be doing?
Yeah, I think it's just very tough for victims to leave these relationships, as it would be for anybody to leave any relationship, right? It's somebody you're in love with, and it's just tough to make that separation. But when you add in this type of emotional abuse, where you're kind of breaking down that victim, so they just don't feel like they have the wherewithal to do these things, to move on without this individual. It's not only that you're worthless, or you're not a valuable person, but I'm the only one who would consider you. I'm the only thing that keeps you going. I provide either the home or the income, or a lot of times they're not working, and they're taking that money and stuff, but they'll make themselves out to be the only one who's going to be there for them. And so that makes it really tough. These are important pieces of evidence too, because it may not be criminal, and it may not be an act of physical violence, but I want to know about that, because it's just important that the fact finder knows this is how this individual interacts with this person, again, to maintain power and control over them. And that's why they're doing these things.
And if you've got a case where you've got a delayed disclosure, this would be a great way to explain maybe why.
Absolutely.
Because you've got a jury, of course, they think as soon as something bad happens, I would call 911, I would go to the police. Like, obviously, this person didn't. So it must not have been that serious, or now they're trying to go to the police for some, sort of bad faith reason. And this could really explain, like, I never went because I never thought I could leave, or I was going under, I thought I was going crazy. So I think there's a lot of reasons other than just, us always wanting to know as much as possible about the relationship, but how we can use it at trial as well.
I think that's a great point, because that's a practical way. A lot of times we recommend using expert witnesses to explain some of the victim behaviors. And of course, staying in a relationship is one of the ones that juries get hung up on all the time. And just how you explain that is the perfect way to have your victim explain why they did what they did in this traumatic situation. And so maybe I don't need an expert, because I can have the victim explain it this way. And that, I think, is going to resonate with a jury. They're going to understand that when they hear that evidence.
Mm-hmm. I agree. We always say, oh, use an expert, but there's obviously not everyone can use an expert in every case. And so to be thinking about also how I can make those arguments through my direct examination and working with the victim and victim advocates. I think that's always nice to have those strategies as well. So you mentioned isolation before, and it's not just, physical isolation. It can be lots of different things. And this, again, the tactics are used to assert power and control, but these tactics all then have an effect on the victim that also makes it hard for them to participate in investigations and prosecution. So I want to sort of walk through a little bit about how isolation in these tactics then also make it really difficult and challenging for us to be working with victims.
Yeah, I think it's so true. This isolation piece, it's a tactic for a reason, right? It works. And it makes it not just tough for that victim not to have the support that they normally might have from family and friends and things like that. But it makes it tough on a victim. Often when an incident, a physically violent incident by a domestic abuser happens, a victim won't call the police immediately. They'll call a family or friend and say, here's what happened. And that person encourages them and supports them. Hey, you need to call the police, or hey, let me come get you, or let's get you to healthcare or to a shelter, whatever it is. The more they isolate these individuals, the less they have that support, and people get they don't know what to do. And so it isn't just that they're isolated and they have no one to reach out to. When things go bad, they may not think I should call the police. They may be afraid to call the police. They just don't know. It's always great to have a sounding board for this, major issues in our lives or major decisions that we have to make. And having someone that you can call is great. The offender knows that. And so isolating that victim, making sure that they don't have that support network is going to be super important.
So thinking about this came up in a lot of cases where I maybe had a victim at the time of trial either minimize or recant. And so we were, taking the strategy of a soft cross, where I was sort of walking through the victim of trying to just point out all these tactics in a way that I could kind of get the jury to start seeing it. And I remember one case I was able to sort of bring out that she didn't have any family in the area, and that it was his family that she relied on for any childcare needs, that she didn't have her own car or a driver's license, and she relied on him for transportation. And these are sort of forms of isolation. And sort of walked through all of those. And then, of course, I didn't make the argument to her. I just sort of brought that out. And then at the closing, I was able to say, doesn't it make sense for why she's saying what she's saying now when you look at this, 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 and this? So I thought that was another way that that isolation can be used.
Yeah, I think that's a very effective strategy for the isolation, to demonstrate with the victim. The soft cross is a great tactic. So obviously we're not going to cross-examine a victim of domestic violence who's testifying for the defendant or who recants, and you suddenly have a hostile witness situation the way we would a defendant, right? Sometimes we will go after those individuals. I don't want to go after a victim. So the soft cross is a great way to elicit information in a way that the victim isn't necessarily put back on their heels. They are answering those questions, and you can sort of demonstrate over time how things have changed and how they have been slowly removed from all their support networks, their family, their friends, coworkers, anywhere that they might be able to get some outside support, or anywhere they might report what's going on to another person. That's what the abuser doesn't want to have happen. And so that's why they isolate them. One of those classic tactics is the abuser who checks the odometer on the car. You can go straight to work and straight back and nowhere else. And they check every evening to make sure that's all that happened, and they know the mileage and things like that. That's isolation, right? I have an avenue to get out of this situation.
Yeah, and I think thanks for bringing that up, because that might not immediately sound like isolation, but what is the purpose of that? It is isolating them to only these controlled movements that they're allowed to have. Yeah.
Right.
So the next one we have minimizing, denying, blaming. So I have an idea in my head of where I usually found this evidence. I'm wondering if your experience is similar, where you have an offender that's then going back to the victim and trying to say, oh, either it was your fault or it wasn't as bad, or if that hadn't happened, this wouldn't have happened.
Yeah, so I think those things are happening all the time. And it might be part of that cycle of violence in the honeymoon phase. I'm explaining to you why this happened. I mean, I've seen it in court. I've seen defendants at sentencing. I've literally had them say this out loud in the court, which is great for me, but there's my victim, and they're still going at that victim from the stand. I've just had one guy who was like, well, if you didn't keep that alcohol in the house, I would, just blaming it on things like alcohol. But they're using this tactic again as a power and control tactic to make, and it's part of that gaslighting, I think, that you brought up earlier. It's like I'm messing with the victim's mind, making them think things that aren't happening are happening, or vice versa. And so it is important to ask about this kind of evidence to find out what is going on, what they're saying, how they are minimizing and blaming. And it's important that victims know that they're going to do these things, right? So when it happens, it registers with them, and they might recognize, I need to share this with the police or prosecutor because it's going to be important evidence. And often in that minimizing and blaming, there might be a kernel of an admission, a confession that I did this, but because of X, Y, and Z. And so it's also very important because we can use that in our trial to hold the offender accountable.
So you didn't say it, but where I heard this was in jail phone calls, right? Because exactly like you said, it happens after the incident as a way to mitigate, as a way to explain, as a way to shift blame. So oftentimes where I'd hear this happening, and a plug for another part of this series where we're going to really dive into the witness intimidation piece and some strategies, is in your jail phone calls. So I think it's important to talk about not just what happened sort of leading up to this incident and the incident itself, but to continue that conversation with the victims you're working with, or within the advocacy and that collaborative response, because there's a lot of prosecution strategies when we've got evidence of this.
Yeah, I think you're dead right. The jail phone calls are a treasure trove of evidence, and this is one good example. I mean, I think we often look for the evidence of trying to make the witness go away, sort of evidence of intimidation, or the "I love you, please don't come to court. If you don't come to court, we can't. They won't be able to convict me." We look for that in jail phone calls, but looking for this as well is going to be super important. And so I don't know who's listening to all your jail phone calls, because I mean, obviously, I listened to some jail phone calls. Our jail did a great job. They were able to like give me recordings and timestamp areas like, I think you want to listen here, here, and here. Yeah, so it was nice, but I didn't always have time. So if you have someone else listening for that information, interns, yeah, make sure that they understand the power and control wheel, and make sure they understand everything that could be helpful in this case, not just a confession about an incident, or threats or intimidation, or trying to get somebody not to come to court. There could be all sorts of stuff in that jail phone call that could be helpful, and we definitely should be listening to those.
And that's a high resource intensive sort of obligation. And I love how different jurisdictions are, kind of mining that information to greater effect. We had to do it sort of retroactively, where maybe there was a case we were looking at with particular, sort of interest, because there were a lot of red flags, or there was some signs of intimidation. So then we would go back and sort of build that case up higher. And because, misdemeanor domestic violence cases, I don't know if there's a jurisdiction that could really say they could listen to every single call. Maybe, and some officers can do it, I think, live. So there's really some cool stuff. I don't want to like go down that road here, but obviously, like you said, a treasure trove. And when we think, down the line about how we're going to present some of our cases when these tactics work, and being able to go forward where a victim's not able to participate because of this. And again, we'll talk about that in our series on intimidation.
Yeah, so there are a bunch of strategies, and I think you've talked about, just explaining maybe why we don't have a victim present. Well, some of this stuff, if we have evidence of these tactics going on, and my judge or jury doesn't see a victim there, are they going to care about my case? If they know about this stuff, they might care. They might say, "Oh, I wouldn't come to court if this was going on either." And so I'm gonna want to hold that offender accountable. In addition to what the violence that I now believe happened, all these other things as well.
This tactic of the using of children, and how different ways this can be used, because it's also a threat, intimidation, related to the children, and whether the children are maybe taken out of the home, or they're not going to grow up with the mom and a dad in the house, which is a lot of people's perfect vision of what they imagine their family to look like. And so the threats of taking away that, or blaming, again, here, you're the one that's responsible for this. But this is an incredibly effective tactic. And I know a lot of cases that I had, I was privileged enough to work where the family court cases were in the same building as the domestic violence cases. And so there was often opportunities to collaborate, because when I was working with the victim, my criminal case was probably not her priority.
Yeah, I think that's a really good point, that this is a very effective tactic, and it cuts right to the victim. Sometimes victims will sort of separate what's going on in the home between what the abuser does to them versus how they are with the kids. And they might sort of think, oh, he's a good father, I don't want to take him away from those kids, even though he's bringing violence into the home. And kids, even if they're not physically in the same room where the violence happens, they know what's going on and it impacts them. And that's an adverse childhood experience that can have consequences down the road. But even the threat, even if it's just an empty threat, it just sort of, if we're going over these tactics in isolation, but they're working in combination, right? All the tactics. And so if you have reduced this victim's feeling of self-worth, an empty threat to take the kids away may be powerful to that victim, even though no court reasonably in the world would end up giving custody to the abuser, right? But the victim may not know that. And so we have to understand it. There are other situations too where, to cope with the trauma of the domestic violence relationship, victims might drink or use drugs or things like that. And that abuser is going to use that against them and threaten with the kids. And so they may feel like, oh, there is something to this. I can't go forward now. I have to do it. There's also, I think, this one reminds me of how offenders will use the civil and criminal justice systems to gain power and control. And so they will file frivolous child custody, or they want to terminate that parent's rights frivolously or falsely as a way to gain power and control. Or they will be that race to the police department or the race to call 911. If I'm the first one to call, I will get the charge against you and do it that way. So that sort of abuse of civil and criminal processes is another power and control tool and tactic.
Mm-hmm. I'd see this a lot in my stalking cases as well, when there was ongoing, like the children were going between the parents still, and there was some visitation. So watching for that. And we've got another part of the series is on stalking and coercive control, and there'll be some overlap in this conversation for sure.
Yeah, and that's the stalking stuff, using the kids to gain information about what mom's doing, where she's going, things like that, sending messages with the kids, things like that are troublesome.
Mm-hmm. So the next spoke of the wheel is originally termed using male privilege. We went ahead and sort of updated it for the purpose of this conversation and just using privilege, because some of it is, we do see male privilege as one of the privileges being used, but we could also see this in other respects, right?
Yeah, and so that privilege is something that, again, folks are going to use. This is the traditional home. This is how things are set up. Or, you have different types of relationships. So it could be a same-sex relationship. And so I'm going to assert a privilege as like the masculine partner, or the one that I'm going to make you the feminine partner, or whatever that relationship is. And because I have that role, or maybe I have a really good job and I make a lot of money, and so that's and you work and you don't make as much money, but I'm going to use that. I'm the breadwinner. I'm that traditional privileged partner in this non-equal relationship, first among equals. That I'm going to use that to control you as well.
I could see this also in cases where one of the partners has a relationship with the criminal justice system or the court system. So one of them is a lawyer or a law enforcement officer. That could also play in here as using privilege to make the other one feel like they don't have access to the court systems, or they're not going to be the one believed, or whatever that be. So what forms of privilege? I think we went over that. Pretrial motion to introduce evidence.
So no, I think you're right about.
Sorry, I think we might have had a little internet hiccup there.
So again, I think all those things Can you hear me?
Yeah.
Can you hear me now?
Yes.
Okay, sorry. Um, so yeah, everything you were saying, I think track 100%. That particularly people involved in the criminal justice system as lawyers or law enforcement, people who have security clearances or high-profile jobs, they'll use that as well. And so you might want to introduce evidence via a motion in limine to say we want to talk about these things because we have evidence that the defendant is using this to control this victim in a particular way, or it plays into the abuse or the physical violence in some way or another. Particularly, say a law enforcement officer who maybe has, and I prosecuted in a small community, so that might poison the force against their significant other by telling stories of, she's crazy, she does this, she's violent, and sowing the seeds of their ultimate disbelief, hoping that they will be the ones to investigate if she ever does reach out to police, which should never happen, right? A police force should not investigate one of its own in a situation like this.
Mm-hmm. So yeah, that 404B other act evidence might come in here if you've got evidence of that. And I think we're at our second to last spoke here of using economic abuse. My understanding is the research shows that this is the most common form, the most common tactic or form of abuse in a intimate partner violence relationship. And it makes sense to me. I feel like when I spoke with victims, this was always a real primary concern of like, how am I going to pay the rent? How, the kids are in private school, and all of those types of things. And so I think offenders know that and use that, and especially post-incident, when a victim is trying to make the decision of like, what do I do now? I think this comes into play a lot.
Yeah, it's such a powerful one. It can undercut a victim's feeling of worth if I'm completely reliant on the abuser to provide for income, for housing, food, clothing, needs for the kids, schooling, whatever goes on. So it's not surprising to me that this is the most prevalent one because it's built right in to many of the others too, right? You're not as valuable as I am, so I can demean you this way. I can threaten you with kids. I'll have access to good legal representation if we go to a divorce or child custody hearing, and whether it's also used. I always associate it with the breadwinner, the person who's making the most money, but it's also used by those who are unemployed, and they take the money that the victim is the only one working, and they take that money and they give an allowance or allow the victim to purchase things only on a specific ad hoc basis. So it can be used by anybody, but I think it goes throughout other tactics as well.
Mm-hmm. I've seen it where somebody comes from a family of money, and so it's not only like I have the money, but now look at all of these sort of backing that I have as well, and this sort of endless support that I have, and you have nothing. And so here we are. Yeah, here we are trying to, provide some support and connect services. And when a lot of times we're like, here's some mental health services, here's this, and they're like, I just need money.
Yeah.
I don't have a place to stay. So I think we need to do a better job of tapping into our victim compensation, our victim funds that we have, and really getting a sense of, what is available, what can we do to support, and what other organizations could do, could help support victims. But I think that if we're ignoring this as part of our job to help make those connections, we're going to lose victims who are just not able to participate with us because they're threatened with losing their home.
Yeah. No, and it brings up working closely with our allied professionals. So working with advocates in the community who often have these resources at the ready, or the connection that they can make very quickly and easily that I don't always know about or would be an extra thing for me to do, or for our system-based advocate to do, who's also, overworked, just like the community-based advocates. But it's exactly what they're designed to do, and it's exactly why I love working closely with a team to support victims through this often lengthy and difficult process.
Mm-hmm. So using coercion and threats. So what are some of the risk factors when we look at what sort of the sub tactics here? What are some of the risk factors associated with these threats, not just to the victim, but oftentimes threats of committing suicide?
Yeah, so huge red flags. I think this one is one that probably resonates most with prosecutors because it sort of fits in our wheelhouse, our standard theory of these cases. In other words, it's just like, oh, I get this. They're all equally important and they're all used, but this one, a lot of red flags. I mean, you mentioned the threat to commit suicide. So one, it's a powerful tactic, not just because often they're not just going to hurt themselves, they're going to hurt the victim, hurt kids, hurt other family members, or hurt a coworker before they kill themselves. That's a big concern. But also, I just used to remember thinking, well, if he kills himself, that's a problem solved for us, right? I don't have to worry about that victim anymore. It's terrible, right? That's a terrible thing to say. That has a huge impact on that victim. That is somebody they were in love with, that they are tied to, they may have history and family and kids with. And so just doing that, whether he hurts anybody else or not, is going to impact those victims severely. And so we do have to think about these things. We really need to engage in safety planning anytime a victim mentions this. And I just also think, working collaboratively with our domestic violence system providers, the community-based organizations that support victims, is important. I just always learn something new when I interviewed a victim. They brought up new things. Things change over time. They're not necessarily, even if they're engaged with advocacies, they're not meeting with them every day. They're not necessarily talking to them every day. And they might disengage at some point, but they might still meet with me and they tell me something and it's important. And I want to make sure, okay, that's a red flag. We need to engage in safety planning. And then I may need to respond in some formal way through the criminal justice system to interrupt that offender's ability to get at this victim.
Mm-hmm. So that's our wheel, and the beginning of this 10-part series where we're going to spend the rest of the 9 parts of the series thinking about the strategies. So with this foundation, hopefully we're going to walk through and identify, okay, what are these barriers and how do we maybe minimize some of the barriers to disclosure, to participation? And collaboration is going to be a common theme throughout the series because it resonates, and it really is the way that we need to be doing these cases to both help provide services to victims, be victim-centered in our approach, but also to hold the offenders accountable. So we'll do that through trauma-informed interviewing, making sure we're identifying co-occurring crimes and charging those either as crimes themselves or as maybe prior bad acts through our 404B evidence. This wheel is going to be a big part of how we're identifying that 404B evidence and perhaps even co-occurring crimes. And then identifying and responding to witness intimidation. And we'll talk about forfeiture by wrongdoing, which is one of our strongest tools to combat witness intimidation, which is also, again, going to reflect back on these tactics and this wheel. So thanks for being with us, John. I know that going forward, people are going to look at this wheel a little bit differently as far as not just educational, but actually like a tool for us to be enhancing our work, presenting that evidence that we hopefully identify, and then that collaboration and that continual safety planning. So thanks for being with us. This is me. This is John.
Thanks, Jane.
Before we sign off, I wanted to plug our AEquitas office hours. That's the 3rd Thursday of every month. Different topics every time we hold the office hours. A lot of emerging issues, really an opportunity to network with your peers, hear how other people are dealing with things that come up. I know we've had a lot recently about COVID and courts reopening and things like that. So I encourage you to register and keep connected with us. So thanks so much.